Welcome, everyone. My name is James Boland, and I'm the founder and president of the Australian Community. Our organisation has been around since 2011. Our mission is to connect Australians who are living in the United States, primarily here in New York and around the US. This is truly a global broadcast, and we do appreciate everyone who is tuning in. We do have a jam-packed agenda. Immigration and taxation attorneys will be speaking with us tonight. Thank you to everyone who have been sending their questions to us. Many of your questions have been aggregated, and for many, they've already been answered as well. I mentioned our YouTube channel. There have been a lot of questions that we've answered, especially around immigration through Zjantelle Cammisa Markel. Again, I urge you to go to the YouTube channel to look for those videos. It appears that a lot of the questions that you've been sending us are the same. So what we've decided tonight is to sort of group these into the top 10 questions that are being asked. Zjantelle Cammisa Markel is the principal of Cammisa Markel, which is a legal firm here in New York specializing in immigration. Hey, Zjantelle, how are you?
I'm good. How are you? How's everybody? Hopefully everybody's good that's on here.
I know a lot of people on the call have some pretty important immigration questions, and the first thing I want to start off with is about the imminent Presidential Proclamation. I know this sort of surfaced last Thursday, about a week ago, talking about the banning of entry of non-immigrant visa holders to the US, and there was concern that the E3 may be wrapped up in that. I know there hasn't been any news since, but perhaps you can just speak to that very quickly.
I think, the annoying part about our current administration is that we have alarm bells that ring before proclamations are actually made. So it sends a lot of people into a lot of stress and worry. From what we've seen so far, it doesn't seem like the E3 visa will be embroiled in that, hopefully. It seems like the E3 is one that is relatively protected. If anything, I think the categories that may be affected are the H-1B OPT, which is for students after they finish their studies at university. They get a year where they can do OPT. They're talking about eliminating that program or shortening it because some students that study STEM subjects get a longer OPT. So I think they're going to reduce that back to 1 year instead of the additional 18 months that STEM students were getting on top of their 1 year of OPT. And there was rumblings that also the L visa might be affected. It'll be interesting to see how that plays out. I know there are a lot of Australians that are on Ls or looking for Ls. We are in the process of doing a number of Ls at the moment. So, we are anxious to also see what this proclamation will say, because the best way for us to be able to plan ahead is knowing what's in it. So we're hoping that by the end of June, we'll have a little bit more clarity, and I'm happy to, get on and sort of explain what that means for all of our Australians and any of our viewers, what it actually means when it does come out. Because sometimes, when it comes out, there are certain things and exemptions, and maybe we might miss something. So I'm happy to explain it when it does.
Yeah, I think we've done 3 videos in 6 weeks. So there's just so many, and each time there's something new or something's changed. So it's pretty scary, which sort of leads me into the next probably 2 questions, and that is around the scenario of someone who is either on an E3 or is about to who was on an existing E3, needs to renew it, or that they want to move to a new employer. Now, obviously, there are no appointment times anywhere other than emergency appointments in Australia, but you have to be in Australia to be able to get one of those appointments. And then there's the whole quarantine issue, and that's a whole nother layer of complexity, especially since they've now announced that they're going to be charging for quarantines. It's not unexpected, but at the same time, it's just another layer of complexity. So we want to sort of look at the 2 scenarios. One is that you're getting a new E3, either through a new employer or an existing employer. Do we go the way of the I-129 here in the US? Or do we do what a lot of people are doing, flying to Australia, doing the quarantine, waiting for the quarantine to then file for a mail-in visa? And who is eligible to actually ask for a mail-in visa?
Let's break it down. So let's start with change of employer, perhaps. Because if you file with USCIS in the US, you can't start working for that employer until the application or petition actually gets approved. So what I think I'd like to explain, which I think a lot of people haven't comprehended yet, is that when we file an I-129 with USCIS, it's a different government agency to Department of State, which is who adjudicates your visa when you go to a consulate abroad. So when you go to the consulate in Australia or anywhere else and they're adjudicating your E3, they're looking at it and they're making a decision within 5 minutes of having the documents in front of them. Those consulates typically don't adjudicate very many visa categories. The only other visa category that they adjudicate is an E2, and sometimes if it's a blanket L. But otherwise, people are going to the consulates with approval notices of their case already having been approved by USCIS in the US, and then the consulate's just really putting the visa in the passport and checking the person, taking their fingerprints, checking that they're not a terrorist or haven't violated terms of their visa. But they're not adjudicating whether that person actually qualifies for the visa, usually, except for if it's an E3 and they're determining whether you qualify for the visa. So that when they're adjudicating it, I feel like they're not looking at it, the documents, as in depth as when you file with USCIS. So USCIS, that's what they're built for, is to receive visa petitions and look at them and adjudicate them very strictly and narrowly. So what we're seeing with the E3s is they are definitely concentrating on the concept of specialty occupation when an E3 is filed with USCIS. And the reason for this is that the E3 regulations state that the definition of specialty occupation should follow the definition of specialty occupation under H1Bs. So the immigration officers at USCIS that adjudicate the E3s are H1B officers that usually adjudicate H1Bs. So the H1Bs have been under scrutiny over the last few years, and cases that would typically not have gotten requests for evidence, say 4 or 5 years ago, are getting a lot of requests for evidence. And so the E3s are following suit. And the way that they are questioning specialty occupation is that years ago, you could say, this job requires a degree in, let's say, marketing or related field, and they would accept that. But now they're narrowing the definition of specialty occupation to being, it requires only a degree in one specific field. So, for example, if you are a lawyer, a dentist, an engineer, an architect, those are great cases to file in the US because they are definitely specialty occupations. You can't do it without a degree in law for lawyer, dentistry for dentist, engineering, architecture, so on, right? But if you're in a field like marketing or finance or business development or market research, or actually we filed a case for an industrial engineer, which I thought would be pretty clear cut that you need a degree in industrial engineering. What they're doing is they're coming back, they're looking at what's called the Occupational Outlook Handbook, OOH. They look up the classification that your job comes under in the OOH. And if the OOH says a degree in if they list more than one degree in the OOH for that occupation, they'll come back and say this isn't a specialty occupation because a number of degrees can be used for this job. So I'll give you an example. For our industrial engineer that we filed, industrial designer, sorry, that we filed, they came back with saying, well, we don't believe that this is a specialty occupation because the OOH says that you could do this job with a degree in industrial design, architecture, or engineering. So prove to us that only a degree in industrial design will work for this job. And the evidence that they want, they list the type of evidence they want. They want to know that everyone in the position prior to the current candidate has had that specific degree. Show us that degree and payroll evidence to show that they actually work there. Go to similarly situated companies, get evidence that the other companies for their industrial designers require only a degree in industrial design and so on. So if you're going to file within the US, the benefit, and this applies for an extension as well, actually, the benefit of an extension is that you can continue working while this petition is getting adjudicated. For a change of employer, you can't, and you've got to wait for it to get for the final adjudication. And if you're going to get a request for evidence, the requests for evidence aren't coming until about 6 weeks in, and then they give you 3 months to respond to that request for evidence because the amount of evidence that you need to give is so much. So now you're at 4 months down the line and you still haven't been able to start with this new employer. So I think that if you are changing employers, the way that you can best control and have some sort of control over the situation right now is to go back to Australia, because you know that you'll be able to get back within about 4 or 5 weeks. So you could say to your employer, I know that I'd be able to start in about 4 or 5 weeks if I go back to Australia. If we file here, I don't know, unless it's a slam dunk, E3 case. But even then it doesn't have premium processing and you don't really have control over when they're going to adjudicate it by. If you're going to Australia, you know that you're going to be in quarantine for 2 weeks. You can't do the mail-in while you're in quarantine. So you'll be sending the application in for mail-in as soon as you come out of quarantine. And they say that it will take up to 15 days. We've been seeing our longest one so far has taken 8 days. So that's good. And it was a concurrent E3. So they were adjudicating 2 E3s at once, and they beautifully annotated the visa with both employers. The other thing that we have been doing is, if the person has any reason why they can't do a mail-in, is requesting an emergency appointment. And as long as you have a letter from your employer and outlining some good and compelling reasons as to why they really need you back in the US, we are generally seeing those emergency appointments getting approved. So that's good, and people going to their appointments and being able to do it. So, James, I'll address the other question as to who can do a mail-in. So you can do a mail-in as long as the visa you're applying for is in the same visa class as the last visa you just got. So if you're on an E3, you can go and do the mail-in for another E3. But if you're changing visa categories, you can't do the mail-in. In addition to it having to be the same visa class, there are a few other exceptions, and I've just got my cheat sheet here, so I'll just read them out so I don't leave any off. But you cannot have previously ever lost a visa or had a visa, a passport, I guess, stolen, or a visa revoked. You cannot have changed your name since the last time you got your visa. So we're facing this at the moment, actually, with a client who got married and had changed her name. So we're going to do an emergency appointment for her instead. You cannot have previously been refused a visa or entry to the United States. So if you've been to a consulate before and ever been refused a visa, even if it was something silly, then you're not eligible for the mail-in and or entry to the United States. Even if that was on ESTA, sometimes people have gone through a time where they tried to come in on ESTA, were refused entry, then they've subsequently got visas and had no problem. But because of that one-time refusal of entry, they wouldn't be able to do the mail-in. You cannot have had any arrests or convictions. So when you're completing your GS-160, if you do have yes there for arrests, you're not able to do the mail-in, but you can, in that instance, we would be requesting the emergency appointment again. And then you also need to be in Australia to do the mail-in. That's a question I've gotten, which is, can I just mail my passport to Australia and one of my family members do the mail-in there? That's not possible. You need to be in the district of consular district or country of where you're going to be doing the mail-in. So we have a client actually that is really wants to travel to Greece, and she's going to hang out for the summer in Athens, and we have looked into doing the mail-in there. Whether she goes through with it or not is going to depend on whether she can get back from Greece, because right now there's the ban on entry to the US from Europe. But if that ban lifts, then I think we're going to attempt the mail-in there as well. And if the ban doesn't lift, then she'll go to Australia, do the 2 weeks quarantine and mail in there. But she doesn't want to go to Australia in the winter anyway, so she wants to spend the summer in Greece anyway. So that's going to be interesting to see how that unfolds.
Is that because there's a consulate open in Greece that she's doing it? She can do a mail-in in Greece?
It's not open yet, but you can book appointments right now in August, and she plans to be there then. I don't know if that appointment will stick, because we did have appointments booked in Bahamas for July and August, and all of those got cancelled. So that's another variable. But she knows all the variables and she's willing to give it a shot. Right now we have someone booked in Paris on July 7th, and that has not been cancelled yet. They're already in Paris. But the hurdle there is getting back out of there. So even if they go through with it, they'll have to go to Australia or somewhere and sit 14 days somewhere else, a country where you can come to the US from, before entering the US. So.
Right. So obviously that sort of answered questions 1 through 4.
Okay, sorry, I went too quick. That's too much.
No, that's okay. I mean, these are the sort of the questions that people want to understand, because they are facing that situation of, obviously if someone has never filed an E3 before, then they have no shot of going to Australia and asking for a mail-in, because they never held that visa before.
Yeah.
So they have to go through
I think another important thing, I think one of the most, the common questions, I know you asked Peter, what's the most common question that you're getting at the moment? For me, it's really, should I be doing the mail-in? Should I be trying to file it from here? Or should I be trying to request an emergency? And I think even if you're a renewal, be cautious of filing the I-129 in the US, again, unless you're one of those slam dunk professions. The other things that you want to keep into consideration, and I'm sorry if I'm repeating myself from the video and people have seen that, but if your company has less than 25 employees, made less than 5 million, and is less than 5 years old, then typically you will also get a request for evidence based on the nature. It's called a vibe RFE, so they want business validation. So they'll come back and say, well, we want to see the lease, the office space of this place. We want to see payroll records to show that this office is actually operating. We want to see. So that's another time where people want to be cautious if there's not very many employees, and especially if you are the only employee, don't file an I-129 in the US unless you're a lawyer and you don't have you'd only be practicing law and that's it. But because if there's only one employee listed on that I-129, they will say that the person could not possibly be doing only the specialty occupation. And they'll say, who's been taking care of the administrative tasks of running the business? And if you don't have anyone you can show, they'll say that, well, then you're doing everything there, and you can't be doing everything. You're only allowed to be doing the duties of the specialty occupation, and that's it. So that's just another warning for everyone who might be the only employee or only one of a couple of employees at their E3 company or any company with respect to filing a renewal in the US.
Well, Zjantelle, thank you so much again. Yeah, I seem to sound like I'm saying this every week. Feels like I'm saying it, thank you, every week to you, but thank you again. What is the best way for someone to contact your office if they, did want to make an appointment or etc.?
Yeah, I think you can contact me directly at Zjantelle Cammisa Markel, but also an easier email address, because I know my name is complicated, is info, I-N-F-O, at Cammisa Markel, and Cammisa Markel is C-A, 2 M's, MMISAMARKEL.com. And if you send it to that one, more than myself and Madeline also gets that email, and because I'm in consults often all day long, back to back, you might get a quicker reply if you use that email address as well, just because I often don't get to emails until later in the evening.
Zjantelle, again, thank you so much, and hopefully your family's bringing you back a doggy bag or something from dinner.
Yeah, hope so. It's my pleasure, James. And again, if anyone has any questions, please don't hesitate to reach out. We love helping the community.
Thank you. Thank you.
Thank you.